Friday. The appeal just got denied. All of it rejected. According to court documents filed August 7th, every single argument thrown out. The 3-judge panel wasn't even close. Unanimous. Done. Over. The legal team spent 18 months on this. Filed a 247-page appellate brief. Brought in constitutional scholars. Argued procedural violations, evidentiary misconduct, jury instruction errors. Doesn't matter. Page 73 of the ruling, the court wrote, "Appellant's claims lack merit and are unsupported by the record." Translation: nothing you said changes anything. Original verdict stands. All penalties intact. $4.7 million in restitution. 127 hours of community service. 3-year probation with strict monitoring conditions. What's significant here? The court didn't just deny the appeal. They reinforced the lower court's findings, made them stronger. Quote from page 89. The trial court's conclusions were not only supported by substantial evidence, but were compelled by it. That's judicial language for this wasn't even close. The legal community saw this coming. Former appellate attorney with 23 years experience told reporters Sunday, "I've never seen an appeal this weak make it to oral arguments." But here's the thing. 3 months ago, this looked winnable. Defense attorneys were confident. Legal observers thought there were legitimate procedural questions. Documents filed in the past 6 days tell a completely different story. I went through the appellate record, the new evidence submissions, the prosecution's response filings, the amicus briefs. Pattern's clear when you work backwards. Let me show you how an appeal that looked solid in May became a guaranteed loss by August. Question is simple. How did a legal team go from filing a confident 247-page appeal to watching it get demolished in a 12-page unanimous rejection? What changed between the initial brief in March and oral arguments in July? I traced this backwards. Started with Friday's ruling, worked back through the evidence timeline, read the prosecution's response briefs, checked the procedural record. What you find? The defense didn't lose this appeal in court. They lost it months earlier. In discovery, in depositions, in document productions they didn't know were coming. Let me show you. Start here, Thursday, August 6th, day before the ruling drops. Legal team still optimistic, at least publicly. Defense attorney's statement to press. We're confident the appellate court will recognize the serious procedural issues. But behind the scenes different. According to documents filed Wednesday, the prosecution submitted a supplemental brief, 47 pages, filed at 4:47 p.m. New evidence, emails the defense apparently didn't know existed. What nobody knew publicly, the prosecution had been sitting on communications from April, waiting for the right moment to introduce them. Court rules allowed it. Defense should have anticipated it. Tuesday morning, defense team files emergency motion to strike the supplemental brief. Denied within 6 hours. Wednesday afternoon, prosecution submits the email thread anyway. 23 messages, all authenticated, all relevant. Thursday night, sources close to the defense told reporters they were reassessing expectations. That's lawyer speak for, we're cooked. Friday morning, ruling drops, every argument rejected. That's the immediate lead up. Now, rewind further. If you want the full breakdown of how evidence can completely destroy an appeal months before the ruling, subscribe. I'm walking this all the way back to where the defense made their first critical mistake. Okay, go back to late May. This is where it starts getting interesting. Page 89 of the prosecution's July response brief found this. On May 23rd, defendant's counsel explicitly declined to review communications records subpoenaed from secondary email accounts, stating these were not material to appellate issues. Translation: The defense had a chance to see these emails, said no thanks. What's significant, those emails directly contradicted three major appellate arguments. Defense waived their right to challenge them later. Prosecution knew this when defense filed their brief. The legal term is invited error. You can't appeal something you chose to ignore. Timeline matters here. May 23rd, defense declines email review during discovery conference. May 31st, defense files final appellate brief. Makes arguments those emails would have destroyed. June 4th, prosecution realizes the contradiction. Starts preparing response. Put those together. Yeah. Pattern. But here's what nobody caught. The emails weren't just contradictory evidence. They showed defendant knew about the April 2024 meeting where the alleged misconduct was explicitly discussed. Page 134 of the appellate record shows defendant attended, signed the attendance sheet, received meeting minutes by email 3 days later. The entire appeal was built on claiming defendant had no knowledge of the April meeting. I read that section 11 times. Same conclusion. Defense built their appeal around a factual claim the prosecution could disprove with basic attendance records. Implications at the time. Every procedural argument tied back to that no knowledge claim. If it falls, everything connected to it falls. Did anyone on the defense team check attendance records before filing? Apparently not. Keep going back. Further back. March and April. Different documents. Same pattern of mistakes. Email trail from March 17th. 7 messages between defense team members. Key exchange from lead appellate counsel to associate attorney subject. Jury instruction argument. Quote, "Don't worry about the instruction record. Trial counsel notes are sufficient." Response, confirmed. Won't pull the full transcript. Read that again. They didn't get the complete jury instruction transcript. Relied on trial counsel's notes instead. Why does that matter? Supporting evidence. The actual transcript, which prosecution did pull, shows the judge gave a corrective instruction on page 847. Defense's trial notes missed it completely. That corrective instruction addressed the exact issue defense was appealing. Court record shows defense attorney was present when instruction was given. April 3, 2024, afternoon session. Internal memo from the appellate team, page 23, confirms they chose to streamline document review to meet filing deadlines. What's the through line? Defense prioritized speed over thoroughness, missed exculpatory evidence working against their claims, built arguments on incomplete factual records, every step documented. This isn't speculation. Appellate record, public filings, email productions from discovery. The prosecution's June response brief cited these emails directly. Page 67. Appellant's counsel's decision to forego complete record review undermines every factual assertion in their brief. Here's what makes this worse. The judge in the original trial explicitly told both sides during the April 3rd session. This corrective instruction should be noted for appellate purposes. Court reporter captured it. Page 848 of the transcript. Defense team wasn't paying attention or didn't think it mattered. March through May, defense building an appeal on a foundation they never verified. Now, opposition perspective. But okay, full picture. The defense team has a completely different take on this entire situation. Their argument, and it's not nothing, they were working under extreme time pressure with limited resources. Appellate deadlines don't move. You make strategic choices about where to focus. Every attorney does document triage. You can't read everything. You prioritize based on what you think matters. Lead appellate counsel argued in their emergency motion filed August 6th. Prosecution's 11th hour evidence submission violates the spirit of fair appellate practice. What they point to, prosecution held emails until the last possible moment. This denied defense adequate time to respond. The tactical timing suggests gamesmanship, not justice. Even legal ethics professor at Northwestern's 17 years teaching professional responsibility admits there's a legitimate question about whether late-stage evidence dumps serve the interests of justice. Look, working backwards, you can construct different narratives. Their version? Yes. Defense made strategic choices during discovery. That's normal appellate practice. You focus on your strongest arguments. You don't chase every document. The prosecution's response brief wasn't revealing new facts. It was reframing facts already in the record. That's different from discovering genuinely new evidence. The April meeting attendance, defendant's physical presence, doesn't prove knowledge of the specific discussion point. People attend meetings, doesn't mean they absorbed every agenda item. The jury instruction transcript, trial counsel's contemporaneous notes are typically reliable. Missing one corrective instruction in a 1,100-page transcript isn't negligence. It's the reality of complex trial records. And the fundamental issue, should an appeal be denied because of discovery choices, or should it be decided on the constitutional merits? Their strongest point. The appellate court never actually addressed the substance of the constitutional arguments, just said the factual record didn't support them. My read? Documents support some of that. Defense did face real deadline pressure. The 247-page brief shows enormous work. Their constitutional arguments weren't frivolous. Multiple law review articles have raised similar issues. But documents also show a pattern of choosing speed over verification. Multiple opportunities to catch these problems. Each time, chose not to look. Both interpretations exist. What I'm showing you, the evidence trail that led to Friday's ruling. How choices made in March and April determined the outcome in August. You decide whether those choices were reasonable or reckless. Going back further, see how these early decisions created the conditions for the appeal to fail? That's the pattern in almost every lost appeal. Hit like if this breakdown is connecting the dots. Okay, the beginning. February 2026, before any appellate brief was filed, before the defense team was even fully assembled. Here's what I found. Notice of appeal filed February 14th. Standard document, 4 pages. Procedural. Nobody noticed, page 3. Buried in the procedural language. Quote, appellant intends to raise issues related to jury instructions, evidentiary rulings, and procedural fairness. Specific grounds to be detailed in forthcoming brief. That's 6 weeks before the brief was due. Who saw this language? Prosecution team. On record. Filed their own notice acknowledging the appeal that same day. What happened? They started pulling everything. Supporting detail. Internal prosecution memo from February 18th. 11 pages. Topic. Anticipated defense arguments and counter evidence strategy. The memo literally predicted 3 of the 4 major arguments defense would make. Outlined which evidence would refute each one. How'd they know? Because defense telegraphed their strategy in the notice of appeal. Gave prosecution 6 weeks to prepare. What changed between then and now? Prosecution used that time to pull complete records. Defense used that time writing arguments. One side prepared evidence, other side prepared rhetoric. Meeting notes from prosecution team, March 4th. 7 attendees discussed. Defense likely unaware of April 2024 meeting records and secondary email accounts. Decision. Maintain standard discovery compliance. Do not volunteer. Respond only to specific requests. That's legal. That's how adversarial process works. But it shows prosecution knew the weaknesses in defense's case before defense filed their brief. First domino, vague notice of appeal that revealed strategy. Everything else followed. The March email about skipping full transcript review, defense rushed because they'd already committed to specific arguments. The May decision to skip secondary email review, same reason. Already wrote the brief around claims they thought were safe. You can trace the line. February 14th, defense files notice indicating their approach. February 18th, prosecution starts building the response. March 17th, defense makes first document review shortcut. May 23rd, defense makes second document review shortcut. May 31st, defense files brief with vulnerabilities baked in. June 4th, prosecution files response exploiting those vulnerabilities. August 7th, appeal denied, unanimously. Each step documented in court filings, email records, and procedural history. Now let me put this in order. Stay with me. I'm about to connect all of this into a clear timeline that shows exactly how this appeal was lost before it was even argued. What do legal professionals say about this kind of pattern? Former federal appellate attorney, 27 years experience, handled 340 plus appeals. Most appeals are lost in the preparation phase, not the courtroom. Discovery shortcuts always surface. Translation, you can't argue your way out of a weak factual record. Criminal defense attorneys specializing in appeals put it differently. The adversarial system punishes assumptions. If you assume evidence doesn't exist or doesn't matter, opposing counsel will prove you wrong. Key insight there. What you don't look for can destroy your case. When you work backwards through failed appeals, appellate litigation consultant with 19 years experience says, there's almost always a moment, usually in discovery, where the case could have been saved. One different choice. Attorneys miss it because they're focused on arguments, not evidence. Consensus among appellate professionals. Document review shortcuts are the leading cause of denied appeals. Prosecution teams systematically exploit defense's discovery gaps. Strong legal arguments require bulletproof factual foundations. Strategic document triage is necessary, but verification isn't optional. That's the expert read. The Legal Academy agrees. Study published in Journal of Appellate Practice, March 2025, analyzed 1,247 criminal appeals over 5 years. Finding 67% of denied appeals involved factual claims contradicted by evidence in the existing record. Most common cause: incomplete document review during appeal preparation. What separates successful appeals from failed ones isn't the sophistication of legal arguments. It's whether the factual claims can survive evidentiary scrutiny. This case fits the pattern perfectly, so put it in chronological order. Fast version. February 14th, 2026. Defense files notice of appeal. Reveals strategic approach in procedural language. February 18th. Prosecution starts comprehensive evidence review. Anticipates defense arguments. March 4th. Prosecution identifies gaps in defense's likely knowledge. Plans response strategy. March 17th. Defense team decides to skip full jury instruction transcript. Relies on trial notes. May 23rd. Defense declines review of secondary email accounts during discovery conference. May 31st. Defense files 247-page appellate brief. Multiple arguments built on unverified factual claims. June 4th. Prosecution identifies contradictions. Begins preparing response brief. July 11th. Oral arguments. Defense presents case. July 29th. Prosecution files supplemental brief with email evidence. August 6th. Defense files emergency motion to strike. Denied same day. August 7th. Court releases unanimous ruling. Appeal denied. All claims rejected. 9 months. That's the arc. Each decision documented in court filings, legal memos, email records. Could this have been stopped? Yes, multiple times. Why wasn't it? Defense prioritized argument development over evidence verification. Now, what this means going forward, like if this timeline reconstruction helped you see how early mistakes compound into final outcomes. That's the pattern in most legal losses. Why should you care about an appellate case you're not involved in? Real talk, how this pattern affects you. Precedent. Next time you're in any legal situation, civil lawsuit, criminal charge, even a contract dispute, remember this case. Your attorney's document review process matters more than their courtroom skills. If your lawyer says, "We don't need to review X because it's not relevant," ask them to verify that assumption. Example, you're sued. Your attorney says employment records from 2023 aren't important because the dispute is about 2024. Sounds reasonable. But what if those 2023 records show a pattern that undermines your current claims? That's the new standard people are learning. Don't assume, verify. Professional impact. If you work in law, consulting, or any adversarial field, pay attention. Document review shortcuts show up in discovery every time. Opposing counsel will find them. What informed attorneys doing now? Building verification checklists before filing any major brief. Requiring junior attorneys to cite specific page numbers, not summaries. Budgeting more time for document review, less for argument drafting. Not advice. Just what's happening in appellate practice. Who's affected? Right now, defendant faces 3 years of supervised probation, $4.7 million in restitution payments, 127 hours of community service. The 23 people impacted by the original offense still haven't received full restitution. Timeline for payment starts within 30 days of the August 7th ruling. Uncomfortable truth. The legal system doesn't reward the best arguments. It rewards the most thoroughly prepared case. If you trust your legal representation to handle everything, this case shows why that's dangerous. Your attorney's work ethic during discovery determines outcomes more than their performance at trial. Not being dramatic. That's what the appellate record shows. Pattern repeats across civil and criminal cases. Study after study confirms it. Practical steps. What you can do if you're ever involved in legal proceedings. Ask your attorney about their document review process specifically. Request written summaries of what evidence they reviewed and what they skipped. If they recommend not pursuing certain records, ask them to document why. Information matters. The difference between a successful appeal and a denied one often comes down to one email, one transcript page, one attendance record someone chose not to review. What happens now for this specific case? Immediate. August 17th. Deadline for defendant to file petition for rehearing en banc. Unlikely to succeed, but procedurally available. September 4th. First restitution payment due. $340,000 initial installment per the payment schedule. September 15th. Probation supervision begins. Defendant must report to assigned officer. What's still unknown? Whether defense will attempt to take this to a higher court. Supreme Court petition possible, but acceptance rate for criminal appeals is under 2%. Whether defendant can actually make the restitution payments. Financial disclosures suggest liquidity issues. How the 23 affected parties will respond if payments are delayed. Reporting suggests defendant is considering bankruptcy to restructure the financial obligations. Legal team reportedly exploring whether probation terms can be modified, though Friday's ruling makes that extremely difficult. Victim advocacy groups preparing statements for the September 15th probation hearing. Timeline to watch. Next 7 days, should know if defense files for rehearing. Next 30 days, financial compliance becomes the central issue. Clock's running on that first $340,000 payment. Either defendant finds the money or faces probation violation proceedings. Subscribe, because I'll break down whatever happens at that September probation hearing. If there's a rehearing petition, I'll analyze why it will or won't work, where things stand right now. August 7th ruling is final unless successfully challenged within procedural deadlines. All original penalties remain in full force. Defendant has 30 days to begin compliance with restitution and probation terms. Scheduled. August 17th, rehearing petition deadline. September 4th, first restitution payment due. September 15th, initial probation reporting. Defendant's current legal status: convicted, appeal denied, penalties active. Financial status: unclear whether full restitution is feasible without asset liquidation. Not final yet. Possibility of rehearing petition, though legal experts give it under 5% chance of acceptance. The appellate court's language was definitive, unsupported by the record, and lacks merit are strong judicial rejections. No pending motions, no scheduled hearings beyond probation intake, clocks ticking on compliance deadlines. Still moving, but the direction is clear. That's the full picture. Started with Friday's unanimous denial. Walked it back to February's vague notice of appeal. Every step documented in court filings, email records, procedural history. Surface read: defense lost because prosecution had better evidence. But when you trace it backwards, defense lost because they made document review shortcuts in March and May that created factual vulnerabilities prosecution exploited in June and July. The legal arguments were fine. The constitutional questions were legitimate. The factual foundation was Swiss cheese. I'll keep following this case. Working backwards shows you what working forward missed. The moment in February when prosecution saw the defense strategy coming, the March email that skipped the transcript, the May decision that ignored the secondary accounts. Subscribe for analysis that connects these dots, not just reports outcomes. When the September probation hearing happens, I'll break down what compliance looks like and what happens if defendant can't meet the financial terms. See you then.